This case breaks my heart. Before social welfare or regulated adoption, young pregnant women had few options. Often the young mother would advertise in the newspaper offering the baby for adoption, usually with a premium, a payment, usually pitifully inadequate, to defray the costs of raising the child. Some people, commonly in England but also in Australia, made a business of accepting the premium for these children, then neglecting or outright murdering the infants. These were known as baby farmers. John and Sarah Makin were baby farmers in Sydney. They accepted a 1-month-old child, Horace, daughter of Amber Murray, with a premium of £3, roughly $600 today. She was told she could see Horace regularly, but John and Sarah then moved and Amber could not find them. Later, workers digging a drain on a property the Makins had occupied discovered the body of an infant, little Horace. Further digging in other premises revealed 12 more little graves. At trial, prosecutors had to prove Horace had been murdered and had not died naturally. Infant mortality was sadly common. They sought to lead evidence of the 12 other graves. Normally, prosecutors can't lead evidence of a prior crime in order to prove a current allegation, but the existence of those earlier 12 graves could surely have led a jury to believe it was unlikely that all 12 had died of accident. In the New South Wales Court of Appeal, Justice Windier said, "In criminal cases, a very frequent subject for consideration being whether an act was accidental or intentional, whether innocent or criminal, the tendency of all courts has been to admit evidence of actions by the prisoner on other occasions, similar to the subject matter of investigation in the case." This point was appealed unsuccessfully to the Privy Council in London. The Lord Chancellor said, "The mere fact that the evidence adduced tends to show the commission of other crimes does not render it inadmissible if it bears upon the question whether the acts charged were designed or accidental." While limited in scope, these decisions underpin the modern rules of similar fact evidence. Sometimes evidence of past offending can be put to a jury if the crimes bear some hallmark which strongly suggests the offences were conducted by the same offender. John Makin was hanged for murder, and Sarah, sentenced to death, received clemency and a life sentence.